Good afternoon, ABA Division for Public Education social media friends. I am, as always, thrilled to be joined by my partner in crime, Professor Stephen D. Schwinn of the University of Illinois, Chicago School of Law. Professor Schwinn, thank you as always for making time to be here with me and my followers.
Great to be back, Kathy. Thanks so much.
So, Steve, we've had finally the term has ended. We've got the last couple of decisions coming out of the Supreme Court on July 1st. There's two big ones that everybody was watching, and the court sort of held on to the bitter end on those. Let's jump right in and talk about Brnovich versus DNC, the voting rights case out of Arizona. Before we jump into what the court did in this case, can you talk to us a little bit about how we got here? What's the importance of the Voting Rights Act? What's happened to the Voting Rights Act? And sort of set the table for what the court was dealing with here.
Absolutely. I'll try to do this quickly, Kathy. Feel free to cut me off if I drone on too long. Okay. So in the
Absolutely.
Voting Rights Act, there were two key provisions that protected voting rights, one on the front end and one on the back end. The front end was a so-called pre-clearance provision that required certain jurisdictions that had a particularly ugly history of voting discrimination to get permission from the federal government before they made any changes to their voting law. The federal government would judge those changes by whether it had a retrogressive effect on voters of color. If it did, the federal government would disapprove the changes, and if it didn't, they would go ahead and allow it. Well, the Supreme Court in 2013 struck that provision, or effectively struck that provision. It struck the coverage formula, which means that we have a kind of empty shell now on the books that is really not doing any work for pre-clearance. The other section that's important is Section 2 of the Voting Rights Act. Section 2 allows an individual to sue if they've been discriminated against by race in the vote. Now, originally, Section 2 seemed to cover intentional racial discrimination, and the Supreme Court said so in a ruling. Then Congress changed the law in 1982 to allow a disparate effect test for Section 2 litigation. And now, after this provision was enacted in 1982, an individual who has been subject to a racially neutral law could bring a claim if it had a disparate effect by race. And so it's Section 2 that was at issue in the Brnovich case. The case involved two provisions from Arizona and Arizona's voting law. One provision was the so-called out of ballot provision. It said if a voter votes, or I'm sorry, out of precinct provision, if a voter votes out of precinct in the wrong precinct, then their ballot will get tossed entirely. It's just thrown out. The other provision was a ballot collection provision, sometimes called ballot harvesting, and it was a ban on ballot collection, third-party ballot collection. What it said was if you're going to submit your ballot, you have to give it to certain select people or take it to the polls yourself. But the state did not allow sort of large groups of people to submit their ballots to a single person who then would take them to violated that Section 2 of the Voting Rights Act because they had a disparate impact on voters of color. And as to the ballot collection provision, because it was enacted with discriminatory intent. And the court rejected all of those claims.
So, Steve, this is a 6-3, pretty partisan, I would say, opinion that we get from the court. And as you're saying, it's rejecting all of the claims coming out of the parties in Arizona, and sort of to some degree narrowing or refining how you would bring a Voting Rights Act violation claim. What's left on the table? Is the Voting Rights Act effectively dead with this group of justices? What's the future?
It's pretty close, and that's a fantastic question, Kathy. The way Justice Alito wrote the opinion for the 6-justice conservative majority really limits the application of Section 2. We won't know exactly how far it's limited until we see some additional litigation under this new standard. What we can say is that Section 2 still allows parties to bring intentional discrimination claims. So if a state or local government intentionally discriminates, a party can still bring a claim. But those are really hard to bring. It's hard to show intentional racial discrimination, and state legislators and local officials who wish to discriminate have come up with really clever ways to disguise it. So it's really hard to show those kinds of claims. But the this new standard, I think, is going to hamstring Section 2 plaintiffs. And let me just, if I can, just go into a little bit of detail why. So what Justice Alito said was the touchstone of a Section 2 claim is that the election rule is not equally open to all, a kind of equal opportunity to all. And he said, in judging that, courts can look to a kind of totality of the circumstances, but he identified 5 in particular that he thought courts ought to take a look at when they're judging Section 2 claims. So the first one is the degree of the impediment to the right to vote. What he said is, some things are kind of a hassle, but we kind of go with them, right? Like you've got to go to your polling place to vote. But other things are sort of outsized hassles, and we'll take that into consideration. Number 2, what were the voting rules in 1982? Remember that Congress changed the law in 1982 to allow these disparate impact claims. And so what Justice Alito says in the majority is that our kind of touchstone basis for judging changes to election law or new challenges under Section 2 is what was the status quo in 1982. Third, what's the size of the disparate impact by race? Is it a big disparate impact or a little disparate impact? That should be a factor as well. And then fourth, the context, the overall state's voting context. In other words, are there other opportunities for voters to vote other than this one restricted way to vote? And we'll take into consideration what those others are. And then finally, fifth, what's the state's interest here? And Justice Alito, said voting fraud, combating voting fraud is a state interest that we take quite seriously. And that's going to count in favor of the state when it enacts election changes.
Steve, I appreciated that factor 2 discussion that you hit upon. I thought that was just really an interesting focus for Justice Alito, and that reference sort of back to what voting looked like in 1980 and 82 was kind of a bit surprising for me. And it just sort of it was this idea of almost original intent, or looking at what the legislatures at the time wanted, and some of that was tied up in it. I also am curious, do you see any of this being tied up or reflective in some of the cases that we heard, although none of them I think made it to full oral argument, the cases coming out of Wisconsin and some of the other states early in the fall with voting changes due to the pandemic? And sort of, is there any reflection that the court's doing of what those changes that have happened in voting, the fact that there was more early voting, there was more voting in different locations, longer hours? Is that reflected here at all?
Those are fantastic questions. And there are a lot of overlaps between this ruling and those issues, and the 1982 question that you raised, that sort of second consideration that Justice Alito identified. Let me explain. So we have a history in our country of, over time, opening up the vote in different ways, right? And we've seen that through, for example, the 15th Amendment, other amendments to the Constitution that have opened up the vote to different populations. We've seen it in the Voting Rights Act, and we've seen it in voting practices among the states. And so to peg the kind of touchstone or bedrock of how we're going to compare current voting laws to 1982 is really going to restrain voting rights plaintiffs moving forward, because we just didn't have the kinds of open voting opportunities in 1982 that we do today. And so judging today's standards by 1982 is a little bit of a mismatch that is going to hamstring voting rights plaintiffs. Now, it does relate to those cases that you mentioned about the 2020 election, and it relates in this way. In the middle of a COVID crisis, what a lot of states were doing, as we know, is coming up with new and different ways for people to vote safely without putting their health at risk. And so if we judge those voting laws, right, by 1982 standards, well, in 1982, we knew nothing of COVID. We knew nothing of health risks in voting. And so a 1982 standard would counsel against a challenge to those, to any restrictions, and even opening up the law in those ways. But, I think it's important to remember that some of those cases turned on a principle that the court has, that the court doesn't like to make changes to election law close to an election. It likes to go with what's on the books. And so there's a heavy thumb on the scale in favor of the rules that are in existence around the time of an election. And that was animating the court in those cases as well.
Great. So Steve, before we move on to the second case from this last day, I wanted to ask about a line that I found interesting in Justice Alito's opinion that may actually bleed into our second case to discuss today. But he talks about the difference between a partisan motive not necessarily being a political motive. And that struck me, and I would love to have a teacher talk to their students about that and what the difference is. So in a case like this, is there a difference between a political and a partisan motive, and what should the court do with that perceived difference?
So, this is a real tough question, and we'll add to the mix a racial motive, right?
Yeah.
And what we know is that racial motives often align with partisan and political motives in today's political climate, just because of the way people tend to vote. And so, if a legislature is making voting changes based on partisan reasons or political reasons, that often spills into racial reasons as well, and vice versa. One of the things that Alito touched on in this opinion that I thought was kind of interesting is, he said, look, there was some early evidence of potential race discrimination in this case, or at least in the ballot collection component of the case. There was a video that came out that looked racist and was criticized for being racist and animating the legislature's decisions in enacting the ballot collection ban. But then what he said is, subsequent decisions then were political decisions and partisan decisions that the legislature was making. And he said those essentially cleansed any prior racial discriminatory animus. And so we now have this rule on the books where if there's some racial discrimination, it can later be cleansed, apparently, if the legislators start talking about politics instead of race. Partisan motives, as distinguished from political motives, more particularly to your question, I think goes to this idea that, legislatures act in both a partisan and a political way. If they have political and partisan motives, we kind of expect that of state legislatures. Where we really go afoul is where they have racial motives. But all this too goes to what the legislature is saying is the intent of any voting restriction. And that's that fifth consideration in the Alito test. And so, if they're doing this for raw political or partisan reasons, that's different than if they're legitimately doing it to combat voter fraud, for example.
Great. Thank you for that. That was very illuminating. And I appreciated your connection of the racial motive. So sort of that tripart of the stool of what the motives can be in that discussion. So Steve, we had a second case announced on the same day, another 6-3 down ideological divisions. Americans for Prosperity versus, I think it's Bonta now. The name has changed with some political seats changing. Can you talk to us about the California Disclosure Act and how this will impact charities in California?
Yeah, really interesting case, and another case that I think, sharp divide along conventional political lines on a court, and I think with potentially very serious implications beyond the nonprofit sector. So this was a California rule that required disclosure of major donors of nonprofits operating in California. The California government said the reason that we're doing this is to combat against fraud in the nonprofit sector, abuse in the nonprofit sector, that kind of thing. And what we're going to do is collect information that it turns out these nonprofits submit to the Internal Revenue Service. We're going to collect that as well at the state level in order to combat wrongdoing in the nonprofit sector. The plaintiffs in the case were politically conservative organizations that said, if the California authorities collect our major donors' names, that's going to discourage them from donating and affect their associational rights under the First Amendment. And the reason why is because if they're disclosed to the public, they're going to fear economic reprisal and potentially even physical reprisal for associating with the organization. This is a lot like a case from decades ago called NAACP versus Alabama, where Alabama authorities required the NAACP to disclose its membership lists. And the NAACP said, look, if we do that, people will die and suffer serious economic reprisal. And they could verify that at the time in Alabama. Well, the plaintiffs in this case were drawing on that theme and making very similar kinds of arguments. The sixth justice majority said, yeah, that's right. And Chief Justice Roberts wrote for the conservative majority in this case and said, what he said is there's a kind of mismatch between what the California government is saying that it's going to use this information for and the actual collection of the information. He said, the California authorities really haven't used this information to crack down on nonprofits in the state or correct for wrongdoing or initiate investigations. What they're really using this information for is just administrative ease. And he said, given that, the threat of an intrusion into a First Amendment right is just way too high. And so he struck the law. Interestingly, he struck it on its face. So categorically, the law is struck from the books. Justice Sotomayor noted in dissent, Kathy, I think what you're suggesting and alluding to, and that this could have much broader implications for campaign finance disclosure laws and even campaign contribution limits, depending on how the court picks up on some of the themes that we saw in this case.
So, Steve, this is a First Amendment case. Is it a free speech First Amendment case? Is it an association first? How do you categorize this one? Because I think we're always quick to try to categorize First Amendment cases and talk about the Roberts Court and free speech. Where does this one fall in that spectrum?
Great question. I think if I'm presenting this to students or as we're talking, it's kind of a mishmash of speech and association. The associational claim is that the individuals won't associate with the association if they know that their identities could be revealed. The free speech claim harkens back to the Citizens United idea that money is speech, right? And this idea that if a major contributor wants to contribute money to an organization, that really is kind of a form of speech as well. All that said, the court doesn't really dig into the details of speech versus association, but it does kind of moves toward a standard for these kinds of claims without really pegging it in either speech or association specifically.
So does California have any backup plans here? Is there anything they can do? Do they need to do anything? I think the chief makes a compelling argument, like you said, that they weren't really using this to combat fraud in the way they said they were going to or the way they wanted to. Do they come back at try and get a second bite at the apple with a different sort of law? Or is this just sort of, as you said, it's a facial challenge, it's dead as it stands, and we'll move on to a different battle?
Yeah, it's possible if California came back and they actually showed that they were using this information to actually combat wrongdoing in the nonprofit sector, then the calculation may change slightly. But it's going to be a pretty high showing that they would need to demonstrate at the court to pass muster under either of the two tests that the court seemed to be playing around with in this case, and I think really difficult to do. whether they need to, it's a good question. As Chief Justice Roberts noted that they hadn't really used this information to initiate investigations. And so I guess the question is whether they can police wrongdoing even without this information. One of the things that Justice Sotomayor noted in dissent, which I thought was interesting too, as kind of a counterbalance to Chief Justice Roberts' points, is that nobody here really alleged the kind of harm that we need to be hearing this kind of case. It was all sort of speculative, right? The idea that major donors would have to reveal their identities might lead to economic reprisal or even physical violence, but nothing like the kind of harm showing that we saw, for example, in the NAACP case that I had mentioned earlier.
Right.
And so what Sotomayor says is, I would have been much happier considering this as an as applied challenge if we had plaintiffs who could show that they were directly harmed by this. Well, then let's go ahead and find an accommodation for them without striking it categorically from the books.
Yeah, I think that's a great nuance. And I find it interesting that so often when you and I have been talking this last year, we are frequently finding the court sort of kicking the can down the road or kicking a case out because it doesn't meet sort of its strict jurisdictional grounds, that there's a mootness or the plaintiffs don't have standing for whatever reason. And in this side, we have a law that the Chief Justice Roberts is saying, California doesn't really need this law in the books. But then we also have Justice Sotomayor in dissent saying, well, these people aren't really harmed by the law. And it's almost one where what are we arguing about? Where's the reality and what's going on here? And it's striking to see, considering the justices are normally so tightly focused on whether there is a harm in something that they can actually take issue to remedy in some way.
Well, what a great point. No, I think you're spot on. And actually, kind of in a surprising sort of way, Justice Thomas picks up on this theme as well and says, look, I agree with the majority. This law has to go, but I wouldn't strike it on its face. I'd look for somebody who is harmed and strike it as applied to them for exactly the reasons that you're stating.
Yeah. So, Steve, July 1st marked the last opinion from this term. I would be remiss if I didn't ask you the elephant in the room that has been present in any conversation as we wrap up the term, talking about court retirements and the potential of Justice Breyer's retirement or not retirement. So with the court ending, we're assuming we're not getting a retirement announcement from him, but that's a best guess. And we may spend the next year hearing about it, continuing to drag on. What's your prediction had on this one? And what do you think the impact of the ongoing debate could be?
Well, I hate to predict anything at the Supreme Court, but I do think that it's unlikely, highly unlikely at this point, that Justice Breyer is going to retire. He's essentially said as much, and he's gone ahead and hired clerks for next term, both of which suggest that he is not seriously considering retiring. And the term is now over, and so if we were to see a retirement, it would have been on Friday or in the very near future, next couple of weeks, for example. But I for myself, I just don't see it happening. Is that going to affect larger debates on the court? We haven't heard a ton about court packing or changing the composition of the court recently, although the Biden commission, as I understand it, is still operating. And I don't ultimately expect any court change plan to get any serious attention in Congress, although I think it's healthy for us to continue having these discussions for sure.
Yeah, absolutely. And I hope as teachers who may be watching this think about their classroom in the fall, I think the notion of sort of the court packing or court reform, depending on which angle you're looking at it, and court reform more generally, there's talk about increasing the number of circuits and what that would mean. I think those are all really ripe discussions for a classroom setting, and you could do some great congressional simulations on those. And it would be a really great way to pull in some of these sort of current events and modern developments in a way that's not just asking students to debate political sides, but really dig into the issues and maybe come up with their own solutions too.
Yeah, for sure. I think you're spot on. You could have a ton of fun with this in the classroom, and given all the issues that are, the court decided this term, and we've got an abortion case, gun rights case, and more religion case on the docket already for next term. There's just a ton to talk about.
Well, Steve, you did a great preview for what's going to be coming up from us in the next couple of months. I hope you will be able to join us back here and help the public ed social media followers get ready for the next term. And maybe we can also do some reflection on some of the larger trends coming out of this last term.
Awesome. Well, thank you, Kathy.
Thank you for
It's been a lot.
joining. Yeah, it's been a really fun term having you around for it. Thank you so much.
Thanks, Kathy. Take care.
Bye-bye.
Good job, Dad.